I wanted to discuss instructing the courts on interpretation. So, in reviewing some legislation during the 2026 California legislative session, I've come across several bills that contain liberally construe language, as well as one that used liberally interpret language. In other words, this bill language is directed at state agencies in the judicial branch that the statute in review should be liberally construed or liberally interpreted. Now, that, of course, raises a question in me, what's the better language to use? First, I wanted to research the use of these phrases. I found that there are thousands of California statutes that use the standard language to liberally construe. However, I also found that there are many statutes that use what I thought was the less common liberally interpret. So first, how many of each appear in state law? Well, an initial search I found liberally construed to be in 4,630 statutes. Liberally interpret I found in 1,432 statutes. Second, this caused me to raise the question, what about the remaining 150,000 plus statutes in the California codes that don't include either of these phrases? So how should those statutes be construed or interpreted by the courts? They lack this guidance that about 6,000 statutes actually have. The third item that I raised was, do the courts even apply this phrase? Do they use liberally construed or liberally interpret, or do they follow the plain language of the statute? Now, while the courts in this state only resort to considering extrinsic language when the statutory language is ambiguous, what would be considered extrinsic language? It's intrinsic language in the statute itself. This guidance language is contained in the statute being interpreted, so I think it would be applied as guidance by the courts. Now, it's not binding on our state courts because, of course, they have and are the final arbiter of what a statute means, regardless of how much guidance the legislative branch attempts to provide. As a result, while the courts may apply this interpretive language, they are not bound by it. Fourth, should either phrase actually be used, or is there, for example, better language that should be used instead? While this language is common not only in California statutes, but also federal ones, it is not the only interpretation guidance that can be used. For example, what about using a phrase instead, such as, this article should be liberally interpreted by the courts of the state to effectuate the intent of the legislature? Although, shouldn't that be the case in all instances? Recall that California courts first determine whether the plain meaning of statutory language can be interpreted. It's only when there is ambiguity that the courts look for guidance or that they follow the many common statutory interpretation principles.